An Indiana transfer on death deed, or TOD deed for short, is used to transfer real property to a designated beneficiary upon the property owner's death. This document allows the transfer to bypass probate proceedings. A TOD deed can be revoked at any time. In this video, we'll cover the purpose of transfer on death deeds, legal requirements for recording a transfer on death deed in Indiana, and how to revoke an Indiana transfer on death deed. We're eForms, the world's largest online database of fillable legal forms, and we're here to make your life easier. To get started on your own Indiana transfer on death deed, click the link at the end of this video. Let's begin by discussing the purpose of a transfer on death deed. Much like a will, a transfer on death deed can be used to transfer property to your descendants. You may want to leave your nephew your home, for instance, or you may want to give your granddaughter a plot of land. However, the key difference between a will and a transfer on death deed is that a transfer on death deed skips probate, which is the lengthy process of distributing a deceased person's assets and settling any outstanding debts. But what is required to complete a transfer on death deed in Indiana? In Indiana, you must sign the document before a notary and one disinterested witness. A disinterested witness is simply someone who won't benefit from the property transfer. From there, you need to take that document to the recorder of deeds in the county where the property is located. To be valid, the deed must be recorded before your death. Another requirement that often causes confusion is the legal description. A legal description of the property is necessary for completing a transfer on death deed in Indiana. This information specifies the property's exact location and may not be readily available online. To locate a legal description, reference property tax statements or the current deed. The recorder of deeds may also have this information on file. Okay, let's say you record a transfer on death deed and then you change your mind. Is there any way of revoking the deed? Fortunately, yes. In the state of Indiana, you can revoke a transfer on death deed at any point before your death. To do so, you have two options. Complete a new transfer on death deed, or create an affidavit that revokes or changes the beneficiary designation. Both of these documents must be notarized and recorded before your death to be considered valid. Obviously, estate planning isn't the happiest topic. However, taking the time to make arrangements now will save those inheriting from you months and possibly years of heartache in the future. So if you're ready to begin creating your own Indiana transfer on death deed, click the link below. Also, be sure to subscribe to learn more about related topics.